go visit your parents. Don't become estranged, because you don't want your siblings having that argument later, I guess. Eh?
You don't, no.
Welcome, everybody, to another edition of FH&P Lawyers Law Talk. I'm Clay Williams. I'm a partner here at FH&P. We've got a pretty interesting show for you today. Today, we're going to talk about the situation where, maybe a person's been left out of a will or feels that the distribution that's been put into a will is unfair and they've been unfairly excluded, or they don't have as much as a brother or sister or something like that. And so with me today is my special guest, Mr. Darren Kautz. Mr. Darren Kautz is the practice lead for the estate litigation, is it department? Department at FH&P Lawyers. And unfortunately, you run across the situation a lot, don't you?
Unfortunately, we do. It's something that happens more often than you think.
Yeah. And so what you wanted to start here, you give me some crib notes to start with. And what you wanted to start with here is I think, taxes and why you should have a will at all, eh?
Totally. So one of the things that people love to talk about are taxes. And, one way to get
talk about them, sure. not pay them.
Sure. That's a good point. Yes. Yeah. Talk about them and not get into the details of paying them too much. But the reason I want to start with taxes, though, is because what happens if you don't have a will in BC? Well, the government is going to actually come after you and try to take some of your monies from the estate if you don't have a will.
Okay. What if you're like me and you just don't plan to die?
Well, you're getting a little older. We all hope
I'm joking,
that you'll.
I know how important it is to have a will.
We all hope that you're going to stay here a long time and work with us, Clay.
Right.
So that's important for us. But if you don't have a will, the government can actually come back and take a percentage of your estate. So, as an example, if it's between $25,000 and $50,000, it can be up to 0.6% of that amount. If it's beyond $50,000, it can go up to 1.4%. on anything above it. So it can escalate quickly and the government's going to come after you and want their money. And a simple way to get around that is come into FH&P and get us to draft you a will.
Okay. Well, there's, what do they say? That the only certainties of life are death and taxes, and certainly can't avoid death, but you can avoid some taxes then, I guess.
Absolutely. Absolutely. It's a good way to avoid having to deal with the government. And it's as simple as getting even a basic will, just something that sets out what your intentions are for later in life if something happens to you, and if you want to give your family any monies.
Yeah, and I'm always stunned at people who avoid a will, and I think a lot of people don't like to come in and see lawyers. It's maybe the first time they're interacting with lawyers, but wills aren't expensive things for the most part.
They're not, and honestly, our firm can quickly and efficiently get you a will and also help you register it so that it goes into the public registry.
Right. And hopefully you can help to actually make a will that's enforceable, because that's what you're here to talk about today is, well, I like that kid better, or this kid, I gave them some money earlier in life, and so, you doing a will yourself can create some difficulties and with respect to the enforcement. And so first of all, like if a beneficiary of a will learns that they've been excluded from their parents' estate or something like that, who can actually challenge a will?
Yeah, that's always the good first starting point is who has standing. Okay, so when I have someone come in, and the courts will often want to hear this as well at the beginning, is who has standing. And in British Columbia, the standing is set out by our legislation, but simply put, it's a spouse, it's a child, or it's an adopted child. And those are really the only people that can seek to vary a will if at some point you find out that there hasn't been a fair distribution. Okay? Stepkids are not legally entitled to vary a will in British Columbia under the legislation.
Interesting. So they have to be formally adopted.
That's right.
Yeah. Okay.
So, that is an important consideration because, again, surprisingly, you have a lot of stepkids that do come into the office and they say, look, Darren, I've been cut out, and the actual children, the biological children, have been included in the will. And I have to tell them, unfortunately, there's nothing I can do to assist you.
Wow, yeah, I guess that's a government policy. You have to draw the line somewhere, I guess, and that's where they've drawn the line.
Yeah, and again, it goes back to making your will and telling your family what your intentions are. Like, I can't emphasize that enough. I've done another podcast with you a while ago where we talked about making sure that, you keep your family informed of what your intentions are. And then that avoids having to come in and see me at some point.
Yeah. Okay, so I'm a person, and I say I don't think I'm ever going to die, but say I did. And I've got a duty then, I guess, to be fair to certain people under the will. And are those the people that can challenge it, or is there anything else?
Well, what is fair is dealt with by our courts. Okay, so our courts have grappled with this over the last multiple decades and set out case law for us as what is essentially fair. Okay, and the court has set out the test, and the test is, does it make adequate, just, and equitable provision for the proper maintenance and support of the willmaker's spouse or children. Okay. So that's the test. And in fancy terms, it's a little convoluted, but it just, are you setting out enough monies for your loved ones? Okay. And is it equitable? Is it equal amongst them? And the court can consider many factors as well. So they can consider, how big is the estate? Okay. So say you have only 2 children, and one child gets, a large life insurance policy. I'll get into this a little bit more in detail, but and the other child only gets $50,000 under the estate. Well, that might be fair then if one's cut out of the estate. But it all depends on how big is the estate? What's the relationship between the deceased and the claimants or the children or beneficiaries? The needs and means of the complainants. Does someone have a disability perhaps that might require more maintenance? And the relative treatment as well. Like, the courts are going to look at how well did you treat mom? How did you
Is there a reason to exclude a child or to diminish a child's return?
That's right. Yeah. How did you treat grandma prior to her passing? Right?
Yeah. But what if grandma was really not a very nice person? I mean, is that taken into account too? I mean, I'm trying to like grandma, but
sure. Yeah. No, the courts are going to look at a multitude of things, including how the families dealt with each other. There's always going to be relationship issues amongst families.
Right.
And, just because you've maybe not had communication with grandma for the last couple of years doesn't automatically get excluded. They're just some of the factors that the court can consider.
So this will be something that you'll be interviewing a person who comes to you with a complaint about some of the things, like why?
Exactly, yeah. So I'll get them to come in and I'll ask them these specific questions, and again, like, all of you watching, if you come in, have these things ready for me, because it will help us navigate through your claim quicker. Other things that they can consider, the courts can consider, are contributions by the deceased to someone. So again, if they gave one of the kids a large sum of money while they're alive, the courts can consider that as to whether they should get more money in the will or not.
Right.
Has there been some misconduct or poor character? So, maybe you just didn't like going to grandma's house, but were you actually mean to grandma at some point that would cause her to purposely cut you out of the will?
It sounds like a trial could be pretty complicated. Then, I mean, you're going to have some siblings say, "Oh, it was the kid's fault," and some say, "Oh no, grandma was so mean." But I guess the court's going to have to wade through all that, eh?
Yeah, it's a lot of narrative. The court's got to listen to a full background history, essentially, of your family. So again, and at the latter part of our conversation here, we'll get into things that I want when you come into my office that the courts are going to require. But before we get to that, though, another thing that I want to talk about as a factor that the courts can look at is estrangement or neglect as well. So, again, how long have you not seen the person that you're saying cut you out of the will? Have there been some extensive gifts, benefits as well that have been given? So many things that the court can see, and these are non-exhaustive, obviously.
What's going through my mind right now is whether I was going to go see my parents or not this summer. And I think you've convinced me I better make that trip.
Yeah.
So.
Yeah, no, absolutely. again, it's important for all of us to make sure we're talking to our loved ones about their estates and talking to the lawyers, talking to the accountants, making sure everything's set up properly so that you don't get into fights later. And if you do, it's minimized at least, right?
Yeah, because it can be very expensive. I mean, if you're talking about a court case, I mean, and who pays for that? The estate, right?
That's right. Yeah, there's many times, where I'll have clients come in and we'll talk about, a $200,000 estate and whether it is financially viable to even get lawyers involved.
Wow. Okay, so my kids aren't going to be fighting over my estate. Then if I have to die, then just by having no money, I've taken some of the acrimony out of my estate, I guess.
There you go. Exactly. Yeah. And finances, are part of even factors that the court can consider as well. So just because you don't need the money isn't an exclusion. So a lot of times, someone will come in and say, "Oh, John has done so well for himself, and he's got his business."
That's a good point, because actually I think a lot of older people see that, and they see one of their children has done very well, one has become like a medical doctor, and one unfortunate person has become a lawyer, and so they think, well, why does the medical doctor need that money? That's a good point. So, and that's not a determinative factor.
It's not, no. So it's another thing that the court can consider, but it's not like a prerequisite by any means.
Okay.
So, and that is important because, again, a lot of people come in and say, John has so much and I have so little. Well, that doesn't make it final, right? The courts will look at that, but they're still going to look at the testator's wishes. So if the testator still said, I want it 50-50, even though John has done so well, that's what the courts might do.
Or if they say, I'm going to give 77% to this child who hasn't done as well.
That's right.
Because the other one doesn't need the money. There still could be a change.
There still could be a change, absolutely. Yeah.
Interesting. All right. Yeah. Okay, now one of the things you've written down here in your crib notes to me is that there is a time frame, I guess, to bring these type of claims.
Yeah.
And I think that our viewers would need to know this. Yeah. So if you're sitting there mulling about doing something, you don't have forever. And how much time do you have?
Yeah, so you have 180 days.
That's it?
That's it.
Oh, boy.
And it's not from...
180 days from when?
Yeah, so usually it's probate or a grant of administration. Essentially what that means is, once you get into court and you kind of formalize the estate. So it's not at the point of someone's passing, but most people don't know when probates happened. You're technically supposed to be told about it, right? So the executor's supposed to...
Oh, if you're cut right out, I guess you might not know.
You might not know. So, the executor is supposed to technically tell people that are in the will, as well as people that should be notified, so spouses and children. Even if they have been cut out of the will, there still is an obligation on them to do so. But that doesn't always happen. So my recommendation is, once someone has passed away, try to talk to your family, try to get a copy of the will, and if there's an issue that you see, you must deal with it right away.
Okay, well, that's not a long time to be mulling it over whether you're going to do something about it. So it's an important point.
Yeah, and one other point on the time frame actually is there's no extensions. So if you miss that time limitation period, the courts, lawyers, we can't do anything. It's a hard and fast stop. So a lot of times there can be extensions. You can go into court and say, well, I wasn't aware or I missed this or that. The legislation is very clear. It is a hard and fast stop on that time limitation period. So, contact us as soon as you have problems is my recommendation.
Okay, wow. Okay, and you've got one final part that I think you want to talk about, and that's evidence. And so they're going to come to you, you're going to interview them, and make sure that they've come in time, they're the right type of person to bring a claim, they sound like they've got a case. And so what do you want to talk about with the evidence? Yeah,
and so after we get through points 1 through 3 that we've already kind of talked about, point 4 often is, well, what are the assets? Okay, because we're going to want to get into that. So what are the bank accounts? What are the benefit plans? What are the life insurance plans? What are the personal effects? Real estate in both BC and outside of BC, because that does make a difference. Now, some of those things don't flow through the estate potentially, like a life insurance policy. So that might not go through probate if there's a designated beneficiary, or if there's someone that will get the life insurance policy, that might flow outside. But it's important for me to know that, though, because again, I want to see what assets have passed from the deceased. So when we're talking about fairness, we can again understand if John got $1 million life insurance policy, and Dorothy only got $200,000 to the estate.
What would you say the key takeaway to our viewers would be from your experience?
Come and see FH&P Lawyers as soon as possible after a loved one has passed away.
So thank you, Darren Kautz, our practice lead at FH&P Lawyers. Thank you for attending. Very interesting. And to our viewers, see you next time.